All right, this is Clayton County Magistrate Court preliminary hearing calendar. Today's date is March the 11th, 2024. This is the state of Georgia versus Franklin Gerard in warrant number 2024 WA 71703, 71704, and 547. No, just those two warrants. All parties of the president have announced ready to proceed. Ms. Freeman?
Thank you, Your Honor. Officer Curry, would you raise your right hand, please? Do you swear and affirm that the testimony about to provide in the matter of state of Georgia versus Gerard Franklin will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Please, you can lower your hand. Please tell us your name and how you're employed.
My name is Officer Curry. I'm employed with Clayton County Police.
How long have you been working with the Clayton County Police Department?
For approximately 7 months.
And were you working with the Clayton County Police Department on February 5th of 2024?
Yes, ma'am.
And prior to joining the Clayton County Police Department, do you have any other prior law enforcement experience?
Yes, ma'am. Adult parole and probation.
And how long did you work with adult parole and probation?
For 3 years.
On February 5th of 2024, were you dispatched to 6714 Terra Boulevard in reference to a holdup investigation?
Yes, ma'am.
What exactly is at that location?
It's the Chevron Mart, the Chevron store.
When you got to the Chevron store, who did you speak with?
With Mr. Abu.
Is Mr. Abu one of the employees at the Chevron?
Yes, he's a store manager.
What did Mr. Abu tell you that happened on that day?
He told me that he witnessed the offender stealing a soft drink out of the refrigerator, and he walked out the store, didn't pay for it.
When Mr. Abu walked out after the offender, what did the offender do?
Mr. Abu described that he walked out to make contact with the offender to address him, and the offender turned around and brandished his firearm that was in his right pocket. And at that time, Mr. Abu disengaged and he walked back into the store.
Did Mr. Abu give the offender permission to take the drink?
No, ma'am.
Was there any kind of surveillance video in the Chevron?
Yes, ma'am.
Were you able to review that video?
Yes, ma'am.
When you reviewed the video, what did you see?
I seen the offender walking in the store, looking around. He kept looking around. He kept looking into the refrigerator. He kept looking around, and he quickly opened up the refrigerator door and picked the soft drink, tucked it under his hoodie, and walked out the store.
Were you able to see from the video the offender showing the firearm in his waistband?
Yes, ma'am.
Did the offender, was he still inside of the Chevron when he showed the firearm?
No, ma'am. At this time, he was outside.
Was he still on the property of the Chevron when he showed the firearm?
Yes, ma'am.
How were you able to identify who the offender was?
From what he was wearing. So the offender, he had on camouflage pants, black sneakers, a black hoodie with a additional hoodie that had multi-colors on it.
Was he still at the Chevron when you got there?
No, ma'am. So when we got there, reviewed the video, and then behind the Chevron, there's an apartment property there, Woods on Tara. That address is 6726 Tara Boulevard. So we canvassed the area and we immediately located him from the description of his clothing, and we located him in about, I believe he was between 2 or 3 other male subjects who ran into building 18.
During this time, did the offender still have the drink that he took from the store?
At that time, I did not see no drink in his hand. As soon as he seen us, he quickly ran into building 18.
Were you able to apprehend him?
Yes. We apprehend at first a male subject, Michael Hopper. He exited the building trying to get in the car with his mother, but at that time we already had multiple units holding the rear and the front side of the apartment, making sure that nobody goes in, nobody went out. We apprehended Mr. Hopper, and then we made contact with the residents that was inside apartment 18F. A female subject, Cynthia Thomas, she came to the door, and we was given permission to clear the house to make sure no one was there. And at that time, that's when we located the offender hiding in the back room between the wall and the mattress, and some clothes thrown on top of him.
And did you get a name for this offender?
Yes, Mr. Gerard Franklin. I think I'm pronouncing the first name wrong.
Did Mr. Franklin make any statements about what happened at the Chevron?
No, ma'am.
Did you or any of the other officers have Mr. Abu identify Mr. Franklin to see if this was the same individual?
When we returned back to Chevron, Mr. Abu was off. He was home.
When you apprehended Mr. Franklin, was he still wearing the same clothing items that you saw in the video and that matched the description?
Yes, ma'am. Minus the black hoodie, which was found in the apartment.
Did you locate the firearm that Mr. Franklin had?
No, ma'am.
Were you able to determine from the video what type of firearm he had?
No, ma'am.
How much of the firearm were you able to see from the video?
I was able to see pretty much how he gripped it and the barrel of it. He didn't point it at Mr. Abu, but the way he held it and pointed at him, it was visible.
Did this happen in Clayton County?
Yes, ma'am.
Were there any other witnesses to this incident at the Chevron?
No, ma'am.
Did Mr. Abu make a written statement?
He had already left. No, ma'am.
Thank you. That's all I have.
Thank you.
Process explanation.
Thank you. Officer, are you the lead on the case?
Yes.
And as far as all the interactions, everything that you discussed that you personally did, do you know if all of that's captured on your body cam?
Yes, ma'am. I'm sorry. Yes, sir.
And if I understand correctly on the timeline, so this is a Chevron, so we're just talking about like a gas station, right? Like a little convenience store.
Correct.
And so while they're in the store, if I understand correctly, you're saying that's where Mr. Franklin takes a drink, correct?
Correct.
And Abu, at no point while Mr. Franklin is in the store, it sounds like he doesn't make contact with him while he's in the store, does it?
When he first walked in, he made contact with them because he's a regular. Mr. Abu also advised that that's not his first time of taking stuff from the store, so that's the reason why he made contact with him outside.
And so let me make sure my question is clear. After the So the only contact that you discussed while they're in the store, is that before the taking of the drink?
The only contact that I seen was from outside after he took the drink.
And so once he takes the drink, then I guess, let me ask, if he's still able to catch up to him outside, does that mean Mr. Franklin's just standing around outside at this point?
He was walking, like he was leaving the property.
And so when you mentioned the term, I believe, brandishing the firearm.
He showed it.
Okay. And when you say he showed it, what color was it?
It was black.
And are you able to tell whether or not it's a revolver or semi-automatic? Are you able to tell which one?
No, sir.
And if I understand correctly, I guess so. There's also no shots fired or anything like that, correct?
No shots fired.
And so at this point, I guess, is there any way that you can rule out the possibility that that's like a BB gun or an airsoft gun or anything like that?
No, but however, the offender, he did make a sudden utterance when he was talking with the other offender, Mr. Hopper, that he stated that my gun is long. He stated that he didn't point it at Mr. Abu, and we tried to explain to him, even though he didn't point it at him, you showed it to him.
And so, and at the point that we're talking about him, I guess, quote, showing it to him, this is occurring outside after the drink has already been taken and everything, right?
Yes, he already took the drink, walked out the store. Mr. Abu followed him to address him, and he turned around facing Mr. Abu, and you could see Mr. Abu still, talking, and then that's when the offender showed his firearm, and then Mr. Abu quickly disengaged and went back into the store.
No further questions at this time.
All right, any redirect?
No, Your Honor, the state rests.
Any evidence on behalf of the defendant?
No, man, just argument, Your Honor.
All right.
The state waives opening.
And yeah, and I guess a couple of things. I'll be asking you to dismiss both of the charges, or at least I would say the armed robbery. It sounds like at most a theft by shoplifting. So that essentially is what I would be asking the court to find. A couple of reasons I'll say that. Number one, as it relates to the possession of a firearm, at this point, nobody can identify that it actually is a firearm for purposes of the statute. It's defined a couple of different ways in the statutes, but both of them require some information. In OCGA 1611, 125.1 offers a definition, but that requires that it be propelled by an explosive of some sort without being able to actually see the firearm to rule out that it's just an airsoft or a BB gun or anything like that. There's no basis to say that this was actually a handgun or a firearm for purposes of the statute. That's part of why I asked about whether or not there was a shot fired or anything like that that would kind of give any more information about it. So at this point, I'll say that the state hasn't met its burden regarding it being an actual firearm at this point. Additionally, even under the charge, as it is charged 1611-106, it does broaden it a little bit to stun guns and tasers to include those also. But at the same time, again, there's no evidence that this was a stun gun or a taser or anything like that that would support a finding that it's a firearm involved. As it relates to the armed robbery, I guess my first issue with it is that it's not, as they say, contemporaneous with the taking. When a person is charged for the state to show an armed robbery, and this is according to Fox v. State, Georgia Supreme Court case, 289, Georgia 34, says the state is required to prove beyond a reasonable doubt that Fox's use of the handgun occurred prior to or contemporaneously with the taking. It goes on to say that the court has also held in this context that the taking of property is not a continuing transaction, which ends only when the defendant leaves the presence of the victim. That is not the case. Instead, the taking is complete once control of the property is transferred involuntarily from the victim to the defendant, even if only briefly. So at the point that Mr. Franklin is alleged to have taken an item and concealed it from the storekeeper, at that point, that's a theft by shoplifting. I would concede that part of it. The taking is over, though, at that point. It's completed, and the firearm is not presented prior to or contemporaneous to that taking. Therefore, it's not an armed robbery. The state has to show that it's shown prior to or contemporaneously. That's not the case here. Additionally, I found another case that kind of gets a little more specific about it. And this one is Page v. State, 334, Georgia App 657. It's a 2015 case. And there, the court talks about the fact that the evidence at trial showed that around midday, the alleged victim was in the basement of their home when they heard someone run upstairs towards the bedroom. Says the alleged victim goes upstairs expecting to find his adult daughter. Once he gets there, the defendant, Mr. Page, is there. He's in the victim's bedroom, coming out of a closet and walking toward the bathroom. Says he's holding Mangum's wife's jewelry box in one hand, the victim's jewelry box in one hand, and carrying the victim's gun in the other hand. At that point, the defendant points the gun at the victim, tells him to get out. At that point, Mangum flees to another bedroom and then outside. The court goes on to hold that, in this case, Page, the defendant, had exercised control over the items, the gun and the jewelry, prior to exerting any force against the victim, who appeared after the defendant had obtained the items. And on those facts, the court reversed the conviction for armed robbery, because that's not an armed robbery. So essentially what we have here, which is that the taking is already done. At the point any discussion of a weapon becomes a topic. So for those reasons, John, the fact that the use of the weapon, which I'm being generous to even agree that there is any sort of use of a weapon, but to the extent that there's any use of a weapon, it's not prior to or contemporaneous with the taking. Put another way on it, what happens after a theft by shoplifting, it doesn't go back and transform it into an armed robbery just because of an alleged firearm or a gun or whatever is shown at some point. The gun's not a time machine, Your Honor. The taking was already done, just like him giving it back wouldn't undo the theft by shoplifting. Showing a gun doesn't go back to transform it into an armed robbery after the fact. So for those reasons, John, I would ask that both charges be dismissed, that the sequence of events doesn't support an armed robbery, and the fact that there's been no identification as far as how this alleged weapon would I guess, expel a projectile, as they say. For both reasons, I would ask that the charges be dismissed for lack of probable cause. But I will concede that there's enough for a theft by shoplifting. Thank you.
All right, Ms. Freeman.
Thank you, Judge. Regarding the armed robbery, Judge, the testimony was that the offender was drinking the soda as he walked out, and Mr. Abu approached him as they were still on the property of the Chevron, and Mr. Franklin brandished his firearm in his waistband. So I would argue that the theft had not been completed and that it was contemporaneous to the brandishing the gun and the taking of the drink. And with that,
I have a question. Didn't he pass all points of sale?
He had passed all points of sale, Judge.
Okay.
He did. And then we would also argue that the testimony from Officer Curry is sufficient to reasonably believe that there was a firearm, as well as the utterance that Mr. Franklin made regarding how long his gun was. And so we would certainly ask that you bind the charges over. And Judge, if you believe that that it was not an armed robbery, we would ask that you bind it over to state court as the theft by shoplifting.
Okay, I'm gonna look at these two cases he cited, and I'll be right back.
All right, thank you, Judge.
All right. Okay, we are back on the record of the state of Georgia versus Gerard Franklin. After review of the cases and relevant law and evidence, the court does not find sufficient probable cause for armed robbery. I do find sufficient probable cause for possession of a weapon during the commission of a crime, and I also find sufficient probable cause for theft by shoplifting. So this case will be bound over to Superior Court because that's a felony, the possession of a crime during a commission, possession of a weapon during a.
Thank you, Judge.
All right, you're welcome. This matter is adjourned. And
May Officer Curry be excused?
yes, of course.
Thank you, Officer Curry.
Thank you.
Mr. Toast came and I think he left.
Right, I see the message in the chat says he's in Judge Malone's. Call or text him when we're ready for him.
Okay. Do you have any other cases, Mr. Rogers?
No, man, I think that concludes my
Okay.
business. It looks like we're still live streaming, just so you know.
Okay. So I don't know who's on, Rachel or Yate, somebody. Can y'all let Mr. Toast know that we're just waiting for him?
Yes, Your Honor, I'll give him a call right now.
All right, thank you.
You're welcome.
Gail, if you can still hear me, do you all still have Ms. Fowler? Hi, do you still have Mr. Franklin there?
Yes,
Yes, ma'am.
Okay, hold him there. I think Mr. Rogers is gonna, there he is. He wanted to speak to Mr. Franklin.
Okay, I have 3 females down here, and they are the only males that I have. Mr. Franklin and the other guy just finished.
Okay. Well, we're just waiting on Attorney Tolles.
Yes, ma'am.
Okay, thank you.
You're welcome.
Excuse me,
And
Judge.
Debark, I'm gonna send you a text.
Okay.
Yes, sir.
Can I be placed back in a breakout room with the jail, please?
Yes.